посмотрим. Здравствуйте, дамы и господа. Начинаем наши очередные вебинары. И сегодня нашим гостем является Аня Шабак, наш юрист. Вообще, ты, наверное, представь себя коротенько на русском, а потом мы перейдем на английский, поскольку сегодняшняя тема требует определенного англоязычного терминологического аппарата. Поэтому им больше имеет смысл говорить на английском, хотя Аня говорит по-русски.
Ну хорошо, здравствуйте, добрый день. Да, я юристом, работаю в компании GSL. У меня образование из Великобритании. Я здесь солиситором работаю, значит, я здесь готовлю все документы по английскому праву.
Наверное, достаточно. Итак, поскольку сегодняшняя тема нашего разговора как, наверное, в прямом смысле связана с английским правом, мы говорим про Shareholders Agreement, поэтому мы и дальше будем вести разговор на английском, однако транскрипция в самое ближайшее время появится как на английском, так и на русском. So, now we are talking about the Shareholders Agreement. As normal, let us start from determination. What is Shareholders Agreement?
Shareholders Agreement is basically a contract. It's a private contract between all or some of the shareholders of a private or a public company, depending on their wish. A private contract which has flexible terms to set out the relationship between these shareholders, the shareholders who enter into this agreement, and the shareholders and the company in which they are participating together.
As I know, Memorandum and Articles is the exact document which regulates the same. Why we are using Shareholders Agreement while the typical document, Memorandum and Articles, exists always?
Yes, that is true. There is already a charter document, the articles, which would regulate the relationship between the shareholders and the company in which they subscribe to the shares. But what we would like to see, apart from this, is a document which would regulate the relationship between the shareholders themselves, not only the shareholders and the company. There are, of course, areas which would overlap between the two documents. There will be some questions which are regulated in the articles as well as the shareholders agreement, but the shareholders agreement would give more flexibility to the shareholders to divert, to differ from the provisions of the Companies Act, which regulates what should be and in what form in the articles of association of the company. And what is the most important difference between the two documents, that as opposed to the articles, which has to be made publicly available in the registrar. The shareholders agreement is a private document. Private document. The shareholders keep it for themselves, and it's not the terms of which are not known to the public. Which of course is a great plus.
So that's a kind of confidential memorandum and articles, which are confidential and private, and which may regulate some issues which are not normally described in the law and in the typical memorandum and articles and so on.
Yes.
So what are the other or the main reasons why we use shareholders agreement instead of Memorandum and Articles and without instead?
Why would put certain issues which could be regulated in the Memorandum and Articles without going into very deep legal analysis? There are certain provisions which cannot be enforceable in case they are actually included in the articles as opposed to the shareholders agreement. If there is a shareholders agreement, any party to the agreement can claim a breach of contract in the future if the terms are not respected by the other parties, to put it simply. Why we recommend to enter into it? I see shareholders agreement as an insurance policy, basically, especially for private companies with a few members who are, of course, in a very good terms when they start their business together. They are in a common understanding what they want to achieve, how they want to manage the assets, how they want to conduct the business. This may not remain the same forever. They might fall out. So basically, the shareholders agreement would like to cover situations which are expectable. For example, the death of one of the shareholders, what would happen then? And situations when the shareholders are completely fall out, they cannot come to an agreement with respect to how to conduct the business anymore, or just some of them would like to leave the business, leave the joint venture, and they would have provisions that how to deal with those situations. So an insurance policy to solve easily, quickly, and most importantly, cheaply, any situations which may occur in the lifeline of the investment of the business, because these businesses are not entered into for a month or two, they might work together for years or maybe decades.
So I see this is the same what takes place with trusts for individual, for private persons. So normally, as I understand this, the clients may ask to use the trust instead of normal offshore company when they would like to insure themselves on different cases in their private life. And the same situation with shareholders agreement to insure themselves in their business life.
Yes, something like that. To be sure that what would happen if certain scenarios occur in the future.
Okay, so to regulate more complicated cases for future, to ensure or secure themselves of the conflicts between each other, or different possibilities to leave the business and so on. So what is normally included in the shareholders agreement? What issues it regulates? I would make two groups in this regard. Why a shareholders agreement is entered into in the first place. Some of them, actually most of them probably, are there to protect the interest of minority shareholders. It's often the case that we have one or two shareholders who hold a shareholding of 60, 70, even 80% of the company, and the rest of the shareholders hold the rest. It is easy to see that without a shareholder agreement, simply on the basis of the Companies Act, if we are talking about company which is run under UK law, so under the terms of the Companies Act 2006, these minority shareholders would have limited protection with regards to their interest. For example, even if certain issues are regulated in the articles in a way that is favorable to the minority shareholders, the articles by law can be changed by 75% of the shareholders. So if an 80% shareholder decides to change the articles in a way that is not so much favorable to a minority shareholder, the minority shareholder could have no say in that. So this minority shareholder may want to include in a shareholders agreement that the articles of association on the basis of which they started off the business can only be changed by a unanimous vote. That he would have exactly the same vote, 1-1, as the 80% shareholder. So the protection of minority shareholders to provide them greater say, greater influence on running the business. My experience so far with clients who turn to us at GSL to draft shareholders agreement is that regardless of the percentage of the shareholder, each of them would want to have equal say in how the business is run. 5%, 10% shareholders would want to have a say. They want to have unanimous votes on the most important decisions that are taken in the life of the business. What do I refer to? As I said, very important, change of the articles of association, changes made to the share capital, the structure of the share capital of the company, or issuing of new shares. How the company wishes to raise further capital, by issuing shares or by taking bank loans. Maybe they want to refer decision making from the board of directors or from the director to the shareholders meeting
in certain questions, which otherwise would be the duty of the directors. This often occurs in shareholders agreement, which are there to protect or to provide more influence for the majority shareholders. This is the second group which I was referring to at the beginning. Majority shareholders may want to have a shareholders agreement so they have influence on the day-to-day management of the business. Because by law, as we know, it's the director who is there to conduct the business on a day-to-day basis of the company. Majority shareholders may want to divert this power and refer much more issues to the competence of the shareholders meeting. And at the shareholders meeting, then again, maybe because of the minority shareholders, they might want to make sure that decisions need to be taken on a unanimous basis. Unanimous basis on, for example, employing employees who receive very high remuneration. They might want to have a say in that, or how much remuneration directors would receive, or whether they change the nature of the business, what the company does, whether they dispose any assets, large assets, buildings, for example, in the future. So these matters, which then become reserved matters, can be referred to the shareholders meeting competence on the basis of unanimous decision. These are very typical issues which we would see in a shareholders agreement.
I see. I was trying to list these criterias, not the criterias, these issues which may have take part in the shareholders agreement. I will try to list them once again. So this is a kind of instrument to balance the interests and rights of
the participating shareholders.
Yes, sometimes it may be the protection of minority shareholders. In some cases, there is protection of the majority who would like to influence on day-to-day business. It may be the limitation or more serious delegation of authority to the shareholders instead of the board direction, regarding the salary or bonus policy, regarding that granting or taking the loans.
For example, these were just examples, but as it is a private contract, depending on the nature of the business the company carries out, the issues can be basically endless. They might have, as you say, in my companies, a management compensation scheme might be a very important issue. How they want to incentivize management. Then the shareholders might want to agree in advance what kind of management incentive scheme they put in place. For example, because part of that management incentive scheme will be the issuance of shares to managers and employees. Then they need to see how they newly issue or they allocate or they sell shares of their own shares to these managers in the future. They mostly want to regulate it right at the outset so that further issuance of share doesn't dilute their shareholdings in the future. So it's depending on the nature of the business and the structure of the business, the issues which are included in the shareholders agreement can be very long and very flexible. But another important group of questions which is included in 99.9% of the shareholders agreement is the regulation of what happens if one of the partners, one of the shareholders want to leave the company. What happens with the shares of the other shareholders? Because when we are talking about small private companies, then the shareholders usually agree and they start off on the understanding that they are going to do business together. They might not want to have any third party on board, or they might not want to have anyone buying up the shares of the other shareholders. So for those cases, there are market practices, there are procedures which have been worked out, which are usually customarily used, preemption rights being given to a shareholder which wants to remain in a business, or putting in place drag-along, tag-along rights, which are quite technical. We do not go into it what this means, but there are mechanisms which make life easy once a partner wants to leave the company. Maybe the partners believe that nobody should leave the company, and there are restrictions on transfer of shares for a certain period of time. There's a lockout period until no one can sell any shares, for example. And then there, of course, with all this unanimity, always there's a deadlock situation when shareholders cannot take a decision because they have equal rights to say yes or no, and they are either 50-50 shareholders or they just have to unanimously decide on certain matters, and they don't agree. What happens in a deadlock situation? Again, there are mechanisms to solve that, but it has to be included in a shareholders agreement in advance, what mechanism they wish to follow in case it happens.
I see. Okay, so I suppose that would be our first attempt to talk about shareholders agreement, and it's good time to finish this time. And we'll continue talking about shareholders agreement regarding the other matters of it next time. So, thank you very much. Спасибо большое. До свидания, до следующих встреч. До свидания.